Good afternoon, members. The Civil Subcommittee of Courts of Justice will come to order. Members will indicate their presence on the electronic voting board. We just barely have a quorum. Clerk will close the roll. All right. Delegate Willett. Actually, you know what, Delegate Griffin, you're here. So Delegate Griffin, if you would just come forward for just a second. So you've got a bill that your concern continues to need some work and probably won't get ready by the end of the session. Is that right?
Yes, Mr. Chairman.
Is your preference that we carry it over or that we strike it? We can do either one.
Strike it if you're willing, Mr. Chairman.
So request the patron motion to, I entertain a motion to strike.
Move to strike.
All right, second, moved and properly seconded that we strike House Bill 202. The clerk will open the roll. Members will cast their votes. Oh, here it comes. All right, the clerk will close the roll. The bill is stricken from the docket by a vote of 7-0. Thank you for your economy on a Friday afternoon.
Thank you, sir.
All right, Delegate Willett. Well, you've got a substitute for your bill, is that correct?
I do. And
Is there a motion on the substitute?
Move the substitute. Second.
It's been moved and seconded. We adopt the subcommittee substitute. As many as favor of that motion will say aye.
Aye.
Those opposed, the substitute is before us. Delegate Willett.
Thank you, Mr. Chair, and I appreciate the opportunity. I think this is my first time appearing before the subcommittee.
This is the greatest subcommittee in the General Assembly. So
I just want to make sure I get this right. Did I call you Your Honor, or did I still say Mr. Chair? I just want to make sure.
because we see so many lawyers here, they occasionally will slip up and use the old term, but I'm not yet that honorable, so you can just call me.
Okay, I appreciate that. I just want to make sure I get it right. No, but thank you. And first of all, to recognize the pieces and parts of this. On the substitute, I just want to recognize the Supreme Court of Virginia and the Office of the Executive Secretary. Appreciate their time and effort to work on that. Maybe have the council just outline that. We'll probably do a better job than I can trying to describe the substitute.
Certainly, yes, Mr. Chair. So there are three main changes in the substitute from the original version. It moves it into a new chapter to Article in Chapter 3 of 801 as opposed to how it was in the original bill. Now, instead of the mandatory transfer to the business or complex litigation docket, there's instead a process for submitting a request for it to go on that docket. And there's also an additional delayed effective date at the end of the bill.
Thank you. Mr. Chair, for the benefit of the committee and the background on this, first of all, full disclosure, I am an attorney, but not practicing right now. But I am a business person, and I do appreciate the complexities of the business world. And unfortunately, yes, sometimes we do have cases that need to go to court. And really what the intent of this bill is to do is to recognize the fact that, yes, some cases are more complicated than others. And some need additional attention, specialized attention, more experienced attention in terms of judges who have that background in dealing with complex litigation. So that's why this bill was brought to me by the various chambers of commerce, just from a business standpoint of really being able to have those needs addressed more efficiently, perhaps more effectively. As you see, this affects actions and controversy that are over hitting at least $100,000 threshold. At that point, it would be through the Chief Justice Office with the Supreme Court to assign the case to the specialty docket. I recognize that is a burden on the Supreme Court that's not there right now. The good news is that we are not asking this would not be creating a whole other set of judges to do this. It's be using existing judicial resources for that. I think the obvious point here is that right now, any kind of civil case, business case is going to go through essentially the same process, regardless of the complexity of it. So this is trying to recognize and make that distinction, and really just, I think, be more effective in how we deal with those cases. I've mentioned the Supreme Court, Office of Executive Secretary, the Chambers of Commerce who worked really hard on this bill. We've gotten input from our friends with the trial lawyers. And yes, there is some disagreement there on the necessity for this. And I would just emphasize in response to that these are different cases, and we're trying to just do the best we can with the docket. So with that, I'll pause for any questions. You may have a few folks who want to speak to the bill as well.
All right. Don't see, my little thing's up here. All right. Any questions for Delegate Willett at this moment, or we'll go ahead and maybe get to the testimony first, and then we can come back and talk to it since it's Friday. Let's let the folks that are here speak. So anyone wishing to speak in favor of the bill, please come forward.
Hi, Mr. Chairman, Keith Martin with the Virginia Chamber of Commerce. As you know, the Virginia Chamber every 4 years surveys the business community from around the Commonwealth, all regions, all industries, to ask for recommendations on business climate recommendations. These recommendations go into what we call Blueprint Virginia. This recommendation is emanating from Blueprint. As you may know, 30 other states have some sort of business or complex business court or business court docket to hear these types of cases. We have a lot of multi-state members who benefit from having used or seen how these cases or these courts work in other states, and think they'll be so good that we actually enhance our legal climate in the state. So for those reasons, we think this will be good for our business climate, and we hope you would support the bill. Thank you.
Thank you. Anyone else wishing to speak in favor? Anyone wishing to speak in opposition to the bill, please come forward.
Mr. Chair, members of the committee, Elliot Buckner for the Virginia Trial Lawyers Association, and we are in opposition to this bill respectfully. This bill doesn't create a mechanism to handle complex cases. It just creates a mechanism to handle business-to-business cases. The $100,000 threshold, I'm struggling to imagine a business suing a business where the amount at issue isn't more than $100,000. That is entirely too low. Further, it includes in the list of complex matters in the line 4010, which is any matter where a business is suing another business. That by its nature doesn't make it complex. It just means it's a business-to-business case. The structure of this also creates a procedure that siphons off already strained judicial resources. It allows any sitting judge anywhere in the state to be assigned to the case. That means that judge isn't available. The court's resources aren't available to handle otherwise very complex or even simple matters for individuals. This bill creates an express lane for businesses and clogs up the travel lanes for all other litigants. If you like the idea of having a mechanism to handle complex cases, then that's what should happen. It should be all complex cases. 2 years ago, I handled a wrongful death case involving a helicopter crash, and I assure you that was an incredibly complex case. That would not be permitted to go into this complex docket. That would have to sit and wallow with worse judicial resources because they're allocated to the business courts. So again, if you are inclined to create some special mechanism for complex cases, we should do that. A truly specialized docket for all complex cases, and it should be an incredibly difficult threshold to get in there. Thank you.
Thank you. All right. Anyone else wishing, anybody online on this bill? All right. Well, this bill has, I note, a delayed effective date in the substitute, right? I think the idea was that there's probably a recognition that is that just more to give it administrative time to get it set up, or it sounds like this bill has maybe some more work to be done from my perspective, but was that to give some time so we have another session to come back and look at it, or was it more just about getting it set up?
I think it was the latter, but I certainly would also welcome the comment that yes, I think we made a lot of progress on it, but I think there may be further perfection for it to happen.
Gotcha. All right. So whoever was in the this room last unplugged the iPad that lets me see who wants to speak, and now it's out of juice. So if you need my attention, just kind of wave your hand, and I'll try and recognize you. Delegate Sullivan.
Thank you, Mr. Chair. I like this bill. In fact, I think my name's on this bill, along with Delegate Willett. I want to thank Delegate Willett for taking the lead on this. And I hear some comments. It's been a long time since I've seen the perfect bill, and I've seen some comments, that may even have some merit. The $100,000 comment is a good one. It's hard to say these words, but $100,000. It's hard to economically fight over anything less than $100,000 sometimes. But in any event, I think that I put my name on this bill because I think it is an excellent idea. This is, full disclosure, sort of the space that I practice law in. The way I envision this working, and maybe we need some more words to make this a little more clear, is that this would be unusual, right? This would not happen with great regularity. I think I take some issues with the comments about taking judges off the, that this would clog things up. My own view is that this would actually, that the big, huge cases clog things up, and managing them better would clear up dockets rather than make them worse. So I think this is it's not clear to me, although it's pretty clear to me where this is headed now. But I like the idea. I hope we'll be able to work in it in the off season and hone it a little better. I think for what are really unusual big commercial cases, there's a place for a special docket like this. So I'll continue to work with you, Delegate Willett, with the bar, with the trial lawyers, to see if we can't make this happen.
All right. I don't see any other microphone lights on. Delegate Keith Kamara.
Yes, I agree with all of the comments that I've heard. As I look at this, it seems to me that there would need to be some mechanisms specifically for judges to really be focused on this particular subject, almost like a specialty area. And I don't, given how much I participated in figuring out the judges we have, I don't see how that happens here. But I do like overall the idea. So I, maybe try to carry it over to 2027 or something like that is probably what I would.
Is that a motion?
Sure, I'll make it a motion.
All right, it's been moved and seconded. This bill be carried over to the 2027 session. We can continue to work on it and work together. Maybe we get to peace in the valley, but if not, at least get it in a position where there's less vehement opposition. Have it come along next year. All right. As many as favor that motion will say aye. Aye. Those opposed? All right. That bill is carried over to 2027. Thank you, Delegate Willett.
Mr. Chairman, I really appreciate those comments and suggestions. Thank you.
Thank you. All right. Delegate Shin. Delegate Shin, you've got a substitute.
I do, Mr. Chair. I'm happy to describe the substitute before you all move it, or whichever you prefer.
We usually move it first, so it's before us.
Sure.
All right, it's been moved and seconded that we adopt the subcommittee substitute. As many as favor that motion will say aye.
Aye.
Those opposed? All right, now in our view, the substitute's before us and we can talk about it.
Thank you, Mr. Chair. I try really hard to avoid courts as a committee, and I thought I put in a housing bill going to gen laws, but somehow I have still wound up in courts, much to my dismay. But Mr.
Is that just because you hate lawyers? I'm not sure what you're saying.
It's because I'm not a lawyer. I feel like a black sheep when I am in this room, sir.
Move to gently lay this bill on the, no, go ahead.
This is what I mean. Mr. Chair, you've got House Bill 910 before you, and in its original form, it was an outright ban that attached a civil penalty to corporations or investment funds that owned single-family homes. In the form of the substitute you've got before you right now, you've got new language that we're adding lines 119 through 123. And basically, a couple of years ago, the General Assembly passed this law that said that we as a General Assembly, or that we as a Commonwealth would conduct a comprehensive statewide housing needs assessment every 5 years. But under the last administration, that did not happen. And so we thought this might be a good opportunity to include some language on what that housing needs assessment would include. So we've added that it would also include a review of parcels owned by any partnership, corporation, or real estate investment trust that manages funds pooled from investors, is a fiduciary to such investors, has a net value or net assets under management on any day in a taxable year, and holds an interest in more than 50 single-family homes or in more than 10% of manufactured home parks, as that term is defined in 55.1-1300. And the reason that we thought that this was an appropriate and apt bill to bring forward at this time is because we know that that there is a housing crisis in Northern Virginia, where our districts, many of our districts are. They say that we are about 190,000 units short from being able to meet the market. And we think that part of the problem is not just the affordability, but it's also supply, which obviously ties into affordability, but that corporate ownership of homes and single-family homes has been on the rise. For example, in 2025, the Lincoln Institute of Land Policy looked at nearly 500 urban counties across the country and found that across all localities, 8.9% of residential parcels are owned by corporations of different sizes. But it also flagged serious concerns for our communities here in the Commonwealth. Harrisonburg, Emporia, Radford, Winchester, Richmond, Danville, Charlottesville, Petersburg. They all have corporate ownership rates somewhere between 15 to 20%, which is more than double the national average. And it seems to me, even a broken clock is right twice a day, once a day, twice a day, whatever. And the White House recently issued a presidential order that says that it'll be the policy of this administration to preserve the supply of single-family homes for American families and increase the paths to home ownership. Because the thing about the impact that corporate ownership of these single-family homes has, we know that it actually has an outsized impact on low-income and BIPOC communities. For example, the University of North Carolina, Charlotte found that the increased presence of corporate landlords has a disproportionate and negative impact on low-income and/or Black households. In addition to finding evidence that large-scale corporate investors appear to be concentrated in neighborhoods with a higher proportion of Black residents, their scholars found that this concentration has resulted directly in a disproportionate increase in the number of evictions and a decrease in the number of minority-owned households in these neighborhoods. So, Mr. Chair and members of the subcommittee, the substitute before you has that language around including this review in the housing needs assessment that happens once every 5 years. It also has additional enactment language around a study that we're asking DHCD to report back on what they know about this. But I understand that sometimes, our chamber feels a certain way about studies.
We'll recognize you just a second, Dr. Maldonado, and we are happy to take testimony. You do note, and so I'll say that as much as you don't like coming to civil stuff, you probably really don't want to go to Delegate Sullivan's subcommittee in rules, which is where bills like this often go. So I'll give you the choice about how you want to do that in just a minute. But Delegate Maldonado.
Thank you, Mr. Chair. I was actually going to speak to that point because given our committee's disposition, I really first want to thank the patron for bringing this bill and addressing this important issue. I think these are one of the ways we see the ability for people to establish generational wealth, to the way that gentrification of our communities is seated is exactly what this bill and other things is addressing. I would love to make a friendly amendment if you would like to consider that we keep the line items in, I think it's 119, to 123, but perhaps strike the language regarding the study.
Mr. Chair, so lines 134 to 153, I think Delegate Maldonado, you're suggesting we strike that, and I would consider that to be a friendly amendment to the substitute. Thank you.
Well,
I think we're trying to do two things, and I think the disposition. I think the fate of this bill is going to be the same regardless of what we do to it. I don't know that we want to focus too much on the specifics.
Sure, Mr. Speaker, or Mr. Chair, not quite yet, Mr. Speaker, but Mr. Chair, I'm pleased to say that some of the opposition that we've had to this bill up to this point, including the bankers and the realtors, have this amendment, removing that enactment and just keeping in the lines 119 through 123, asking that to be included in the housing needs assessment would get our stakeholders to a position of neutrality, if that at all has any impact.
I'm confused. So we're going to strike the underlined language in lines 119 through 123.
No. We're going to keep that. That's the only thing we're going to keep. We're not going to do anything.
And we're going to get rid of the enactment clause.
Mr. Chair, yes, that would be to avoid going to Delegate Sullivan's committee.
Okay.
But we're hoping that in getting our stakeholders to neutral, we can maybe keep this moving as a point of conversation, because I think there was some interest in keeping it alive.
Okay. You can make it, if that's a friendly amendment, I'm happy to entertain it.
Second.
Moved and seconded, we adopt the amendments so we're going to basically strike enactment 2, right? That's it, that's really all of the substitute. All right, it's been moved and properly seconded. As many as further motion will say aye.
Aye.
Those opposed? All right, that motion carries. All right, any other conversation from members of the subcommittee?
Second.
I want a substitute motion.
I have a substitute motion.
We'll carry this over.
Move that we carry this over till next session.
All right, it's been moved and seconded. As many as further that motion will say aye. Aye. Those opposed?
Nay.
All right, motion carries.
Thank you, Mr. Chair. I hope to not be before you again. Thank you.
All right, Delegate Reeser,
Where would you like me to present from?
wherever you feel most comfortable.
Good afternoon, Mr. Chair. There are some line amendments before I begin.
With the amendments?
All right, Clerk, Council, will you sort of report the amendments we're about to adopt before we say aye?
Yes, sir, Mr. Chair. So there are 3 that are printed in front of you, and we actually have an additional that Delegate Reason and I spoke about before. So the first is going to be on line 50. After character, we're going to insert or. On line 50, after subsection C, we're going to strike the remainder of line 50 and through subdivision D on line 51. On line 46, after the citation to 59-1-593, we're going to insert scientifically reliable before test. And the last one is on line 54, after Title 18.2, we're going to insert a new sentence that says, any action brought against an entity under Clause 3 shall only be for a cause of action occurring on or after July 1st, 2026.
All right, does everybody understand the amendments before us? It's moved and properly second. We adopt those line amendments. As many as favor that motion will say aye. Aye. Those opposed? All right, the amendments are there before us. Question for council. That last amendment that you read, that is probably legally necessary because of a provision of the Constitution of Virginia that says that statutes of limitation can only be retroactively changed for natural persons. And so we need that language for entities so that the court doesn't read this as a potentially unconstitutional bill. Is that correct?
That's correct. So it's specific to sexual abuse as a minor, and it's specific to natural persons. So my understanding is that we couldn't retroactively apply it to entities, which is why this sentence is being added.
Got it. All right. Delegate Reeser.
Thank you, Mr. Chair. So with scientific advancement in DNA evidence and our growing understanding of childhood trauma and the effects of it, which can affect memory, emotional processing, can cause disassociation that makes it difficult for survivors to recall or disclose events until later in life. Virginia's civil statute of limitations for child sexual abuse lacks any mechanism that allows for later discovered evidence. And even in cases where there is a DNA match, a confession, or a witness coming forward. So these rigid timelines have in the past protected repeat abusers, and it also incentivizes institutions to conceal abuse until the statute of limitations has expired. This bill, HB 1020, would amend the code to allow for newly discovered evidence, including DNA, confessions, or corroborating witness testimony to be considered by a court. It does not change the filing period itself. It doesn't change any of the burden of proof or evidentiary rules or any court procedures. It just simply strengthens public safety by discouraging institutions that might otherwise conceal these abuses until time limits have expired.
All right. So everybody understand what we're doing? This sounds very similar to a bill that we heard last week. Slightly different approach to it. It's got a different code section that it's working on. And ties it to some specific triggers, so it's not just a complete, elimination, but tries to broaden it out, it sounds like, for a lot of foreseeable circumstances. Anybody here to speak in favor of the bill, please come forward. There's some folks online too, but anybody in person want to say anything nice about this bill? No? Okay. All right, online. Ann, Kraft, Taylor, Tatus, I'm sorry.
Yes. Ann Graftatis. Thank you so much for having me back. And it is I'm in tears because this issue has been a driving force in my life. And to have two parties sponsoring bills to do what needs to be done in this state is very heartwarming at a time when I feel like we're all being torn apart. And I am in favor of this bill. I would like Delegate Hamilton, I would encourage to, instead of putting more stipulations as to how to open it up to people, to approach it as we are with the custodian and guardian. And to answer the chairman's question last week is people who stand in loco parentis is what the bill for Delegate Hamilton is speaking to. But when we talk about, we mentioned that the average age, and this is not an assumption, Child USA, Enough Abuse, is that there are national organizations that say the average age is 52 when adults can finally report out of fear, trauma. This bill speaks not just to people who stand in loco parentis, but actual parents, people. I mean, the amount of incest that people are getting away with, and if you read any of the VCPA, the Virginia Child Reporting, Alicia's Law, any of those that have come out, or if you go on the DFS website and find these reports, these people that are going to jail are not serving jail time. So to limit the people that should be going to jail because of, like I said the other day, because oops, your time has run out, because currently revival windows that are open permanently, Maryland, New York City or New York State, Ohio, Vermont, Maine, Iowa, Indiana, Arkansas, revival age limits. Rhode Island, funny enough, has 53 as theirs, 55, and ours ranges from 15 to 20 after the infancy, so that you reach the age of majority. And that leaves about 20 years after what the nation knows is the average age. The median age is 49. And we talk about trauma and what children go through all day, every day, whether it's in school or in society. So to ignore this factor, which is a cold, hard truth, the protection of children has never been a political priority. We all rage about special interest groups influencing government, but when it comes to child protection, it has yet to occur to us to become one. Many states are beginning to break through the shield of silence with revival laws that restore survivors' ability to sue even after the original statute of limitations has expired. Many states have eliminated standard or statutes of limitations or adopted revival legislation of civil claims. Is that there is no clock that runs out on the trauma of abuse. And I encourage you to merge these. You two have a beautiful meeting of the minds and show Virginia that we're not in opposition of everything, and protect children, not just from the custodians, but also from their actual biological parents, which this bill would more so direct to.
Thank you. All right, Sandy Johnson.
Thank you, Mr. Chair, members of the committee. My name is Sandy Johnson, and I am here to speak in support of HB 1020. I am the Senior Legislative Policy Counsel for RAIN, which is the nation's largest anti-sexual network. We run the National Sexual Assault Hotline, where we hear from survivors every single day. I was also a prosecutor for 20 years, where I primarily prosecuted crimes of violence, including sexual assault. RAIN strongly supports HB 1020 because it will open the doors to justice for more survivors. Currently, the statute of limitations in Virginia for child sexual abuse is 20 years from age 18, or when a physician or psychologist first communicates to the survivor the connection between the abuse and the survivor's injuries. And I would echo the statements of the previous speaker that the average age is approximately 52 of when child sexual abuse is disclosed. 60 to 80% of child sexual abuse is not disclosed well until adulthood. HB 1020 takes a measured approach by extending access to courts for survivors whenever there is corroborative evidence, such as DNA, newly discovered witnesses, or a confession. This bill does not change the rules regarding the admissibility of evidence or the burden of proof. Instead, it recognizes that when there is sufficient evidence to hold perpetrators accountable, they can be held accountable. And when survivors are ready to seek justice, that they are not permanently barred from the courthouse, regardless of how powerful the evidence. Just this morning, I was emailing with a survivor of child sexual abuse. She was abused by a coach, but never came forward well until adulthood. She didn't come forward because she did not think she would be believed. But decades later, it was discovered that this coach had sexually abused multiple victims, some abuse happening years after her abuse. Unfortunately, because of the statute of limitations, this survivor could never bring an action for the harm she suffered. The perpetrator was never held accountable for his actions. This bill would return control to the survivors in similar situations and allow them access to the courts. RAIN urges support for HB 1020. Thank you, and I'm happy to answer any questions.
All right, thank you. Anybody on the subcommittee have any questions for Delegate Reeser or for Ms. Johnson? All right, is there anybody in the audience I should ask seeking to speak in opposition to this bill? All right, don't see any. All right, so again, we've acted on this. Again, this isn't necessarily in conflict with Delegate Hamilton's bill. They could work together. We could decide, we'll get them both in front of full. There may be some opportunity to combine them, or they could go along separately. I think all those things could work procedurally in talking to council. So is there a motion?
Move to report.
Second.
It's moved and seconded that the bill report as amended. Did we get Delegate Leftwich's amendment too?
Yes,
Okay.
that was the
All right.
third
All right.
one.
So those are all in there. All right. So motion and a second to report as amended. The clerk will open the roll. Clerk will close the roll. This bill reports 7-0. All right.
Thank you
Before
to
we,
the committee. I'd just like to say I hope all of my bills are in civil sub.
all right. Thank you. So there we go. All of them. Before we leave, actually, if I can get a motion to reconsider the vote by which we took Delegate Shin's bill by for the under Rule 22.
So moved.
Second.
It's been moved in second. As many in favor of the motion will say aye.
Aye.
All right. I'm convinced that with the removal of the enactment clause, this may or may not need to go to the other bill. And so if we report it out, then it gives us more options going forward before full. If it turns out it does need to be continued, we can. But by doing a motion to report, it gives me a chance to check with folks in leadership and others to make sure we're still on track. So rather than just ending the opportunity to deal with it here in subcommittee, I think it would be better if we go ahead and move to report. So
I move to report.
Second.
everybody get where we are? With sub, yep. So with the substitute and the amended substitute.
Yeah, amended substitute.
All right. So there's been a motion properly seconded to, we already reconsidered it. Now there's a motion with a second to report with substitute. As amended. Get that convoluted enough. All right. The clerk will open the roll. Members will cast their votes.
Happy Friday.
All right. The clerk will close the roll. The bill reports by a vote of 8-0. All right. Keep that conversation going. All right. With that, I think we've completed our light Friday docket. Get everybody on the road, except for those of us that have to go to Crimson for bills. The committee will rise.